Don't stop. Leo. Karaoke?
And them are brand new. Them are brand new, aren't they? I say they're still a little shiny. I looked at lamps in the petroleum yesterday, and it's all brown. And I'm like, ugh, what the hell's in it? I asked Courtney, I was like, so do I shut this off since I'm up on stage or what? And he goes, you have an ear thing? I'm like, no. I figured we'd have them back in investigations, but they don't. I mean, they don't fucking wear radios, so what's the point? Yeah. Just the guys that bought them themselves, right? The SWAT team probably bought you some. That's the SWAT teams or yours? But you probably have your own on patrol, don't you? No, you didn't buy one like everybody else did. Well, I mean, do you really need them on patrol? I get thought back like when I was still on patrol when they bought them, and I'm like, I just said, just thought to myself, I'm like, I can't think maybe one time in the last 5 years that I would have needed it. So what's the damn point? Each one of them spent like $60 a piece, didn't it?
It's only really to keep people from hearing what's coming across your radio.
Yeah.
They were having some problems with cheap mics and stuff they bought.
Some of the guys buy newer ones.
What's that?
Or the lapel was a piece of crap because it went and plugged into those, didn't it?
If everyone could take their seats, please, we will be getting started very shortly. Thank you.
All rise. The Honorable Justices of the Supreme Court and Honorable Judge for the United States District Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting. You may be seated.
Good evening. Welcome to the special session of the Supreme Court of Kansas. We are very pleased to be holding this session in this beautiful auditorium at Garden City High School. Since 2011, our court has made large efforts to be more accessible to the people of Kansas whom we serve. And these efforts help Kansans learn more about our court and the role of the judiciary in Kansas society. For example, tonight we will not be asking you to participate in a public opinion survey. We will not be asking you to tell us how you think that we should vote on how we decide these cases. But as you'll see, we will be asking the attorneys questions to help us do our job, which is to uphold the law and to make the decisions that the law requires, and not make our decisions based on our personal beliefs or on politics or special interests. We strive to maintain fair and impartial courts in Kansas. Our court has held special sessions in Salina, in Greensburg, Overland Park, Wichita, Pittsburgh, Kansas City, and Hayes. And we have especially liked visiting schools because we have found that our students in Kansas show a great interest in how the Supreme Court operates. Before we proceed, it is my honor to introduce the colleagues who are seated up here on the bench with me, and I'm going to introduce them by their name and their Kansas hometown. And I'm going to start with the jurist to my right. She is most senior on the court next to me, and then I will move down in order of seniority. To my right, this is Justice Marla Lukert. Her hometown is Goodland. To my left, Justice Carol Beyer. Her hometown is Kansas City, Kansas. To the right of Justice Lukert is Justice Eric Rosen. His hometown is Topeka. To the left of Justice Beyer is Justice Lee Johnson. His hometown is Caldwell. To the far right is Justice Dan Biles. His hometown is El Dorado. And to the far left, next to Justice Johnson, is Justice Caleb Stegall. His hometown is Lawrence. In order to make an event like this possible, it takes a tremendous amount of planning. And I would like to take a minute to thank all of those people who worked so hard to make this such a successful event. It starts with USD 457 and the superintendent of schools, Dr. Steve Carlin. And I want to thank all the high school staff who assisted with the arrangements for this evening. You have gone out of your way to make this much easier for our staff to help plan this event, and we appreciate your hard work and your enthusiasm. So we extend a very warm welcome to Superintendent Carlin, the school board members of USD 457, and the high school teachers and the staff, and of course the students who are in attendance tonight. This session is being video streamed, so we appreciate the expertise and assistance of the Garden City High School Technology Department, and we thank instructor Jesse Bernal and his students. I also want to thank all the law enforcement and security personnel who are in attendance this evening. I also want to extend a special thanks to our honorary bailiff. This is Judge Donna Blake from Syracuse, Kansas. Judge Blake was appointed a district magistrate judge in 1977. Judge Blake, congratulations on your outstanding service during those many years, and thank you for opening our session this evening.
Thank you, sir.
Also want to welcome and thank Chief Judge Wendell Wurst and the judges and staff from the 25th Judicial District who are not only helping us today, but also have been working hard to help plan this event. Also want to welcome the Finney County Bar Association President, Zach Schultz, and other members of the Finney County Bar. We are pleased to see so many middle school, high school, and college students with us this evening. As you may know, this afternoon, the justices had the opportunity to visit some of your schools and enjoy their visits with the students and their teachers. Justice Rosen and Justice Biles went to the community college. Justice Johnson and Justice Stegall went to the high school here. Justice Lugert went to Horace Good Middle School. Justice Beyer went to Kenneth Henderson Middle School. Thank all of you for coming this evening. As you probably know from all the media attention, you are helping us make history tonight. This is the first time since Kansas became a state in 1861 that we have held hearings in Garden City. And this is the first time, any place in our 154-year history of this state that the Kansas Supreme Court is holding an official session in a high school. With your help this evening, this should be a great session. We warmly invite you to a reception in the lobby at the conclusion of our hearings. The justices welcome the opportunity to meet you and to visit with you at that reception. I'm informed that the high school culinary arts class has prepared the food and they will serve at the reception. So thank you, culinary arts instructors Karen Burden and Jacob Huth, for working with your students to plan the reception. I'm now going to call upon Ms. Heather Smith, the clerk of the Supreme Court of Kansas, to do the honor of calling tonight's special docket. Ms. Smith.
Thank you, Mr. Chief Justice, and may it please the court. Appeal number 108963, Betty Bourne et al. Versus Sharon Bourne et al., Sedgwick County, briefs both sides.
Jim Walker present, representing the appellant. Ready for argument?
Todd Shadid, representing Sharon Bourne, the appellee, present, ready for argument.
Appeal number 109995, State of Kansas versus Patterson, Sedgwick County, briefs both sides.
Good evening, Your Honors. Assistant District Attorney Lance Gillette on behalf of the State of Kansas, the appellant.
May it please the court, Richard Ney, on behalf of the appellee, Dante Patterson.
Appeal number 110415, State of Kansas versus Logsdon, Reno County, briefs both sides.
Thank you. Shannon Crane, attorney for the appellant, ready for argument.
If it please the court, my name is Keith Schroeder. I'm the Reno County District Attorney. I'm on behalf of the state of Kansas, the appellee in this matter. I'll be accompanied by Stephen D. Maxwell, Senior Assistant District Attorney, who is also trial counsel.
Your Honor, that concludes the docket.
Thank you, Ms. Smith. Before I call the first case officially on the docket, I did want to announce that there are 3 cases on the docket, and the court intends to take a 15-minute break after the arguments are concluded on the second case. That gives everyone a chance to get up and stretch your legs, and if you choose to leave the auditorium, if you do not care to hear about the third case on this evening's docket, as you probably have read or heard in the media, it is a murder case. With that, I will call the first case on this evening's docket, case number 108963, Betty A. Bourne et al. v. Sharon L. Bourne and Todd J. Bourne et al. Proceed.
Again, my name is Jim Walker. I represent the appellant, Betty Bourne, on behalf of the Betty Bourne, or the John Bourne Trust. I'd like to reserve 3 minutes for rebuttal, if that's permissible.
3 minutes is granted. Thank you. Counsel, before you start, if you had not prepared to do this already, for the benefit of the audience, would you give us a 1 or 2 minute factual overview?
Certainly. This is a case that is on appeal from Sedgwick County, wherein the lower court granted summary judgment in favor of the defendant and against my client, the appellant. We then went to the Court of Appeals. The Court of Appeals affirmed the trial court and sustained that order of summary judgment. The case involves a business transaction that was pertaining to the sale of a quarry business. The seller was Sharon Bourne. The buyer was John Bourne Trust and Todd Bourne, later Todd Bourne Trust. The transaction involved less than $2 million. It was structured so that principally no monies were paid up front. It was used with promissory notes collateralized by security agreements. The security agreements were the stock of 2 entities that were the subject of the transaction. The transaction took place in the fall of 2010. The buyer, John Bourne, got sick shortly after that and became terminally ill and died in September of 2011, more than 4 years ago now. John, at the time of his death, had a surviving widow, Betty Bourne, who became the trustee. She is my client in this case. The transaction contained an event of default, several events of default, most of which were financial events. One event of default was the death of John Bourne. John Bourne died in September of 2011. That triggered an event of default. A notice was given. The parties then have been in dispute since that time over issues concerning the notice, issues concerning whether or not an objection was made, issues concerning the tender of the amounts due under the promissory notes, and related aspects.
Counselor, can I simplify this and forget about successors in interest and where we sit right now? We have the first transaction is Betty Bourne, or Sharon Bourne sold equipment and property to her son Todd and her cousin John's trust, correct? In the note number 1.
Yes.
Except she didn't sell it to them, she sold it to the LLC that they formed, TJ Leasing.
That's right.
So the parties to that first agreement were Sharon Bourne and TJ Leasing. The parties to that first note.
Yes.
And so your client...
Well, with guarantees.
Yeah, but your client is a guarantor, not a debtor.
That's true.
And the second transaction is between Sharon and now Betty. And that was for the sale of the stock in the stone quarry business.
Yes, up for 50% of the stock in the stone quarry business,
Okay.
yes.
And so the point I'm getting to and want to make clear is that we're going to be talking about pledge agreements. But what we have are, on that first note, it's the pledge agreements from the guarantors, not the debtor.
True.
Okay.
What I want to talk about, in addition to answering any questions that you might have today, and use my time to talk about whether or not there was error committed at the trial court level, and then again, not resolved to our satisfaction at the appellate court level. And that has to do with 2 points. One relates to the interpretation of the Uniform Commercial Code Secured Transactions, Article 9-620, that provides the conditions under which a secured party may take collateral in strict foreclosure in the event of default. And our argument on that topic is that the statute says that a creditor can take the collateral in strict foreclosure in full satisfaction of the underlying debt, as applies to this case, only if the debtor does not consent, or only if the debtor fails to object within a timely manner.
I think,
Debtor does consent.
Say it
The
again?
first condition is the debtor does consent.
Yeah.
Yeah, okay, thank you.
Does consent, and if the consent is, the consent can be the failure to object within the 20-day period from the notice.
Did TJ Leasing object?
TJ Leasing had 2 partners. One was Todd and one was Betty. We believe TJ Leasing did object. The lawyer representing then Betty Bourne sent a letter containing several conditions and complaints and problems that is a part of the record. And then there was also a lawsuit filed, I think it was on September the 28th, within a very short period of time after the declaration of default. And that lawsuit included TJ Leasing, and that lawsuit included Bourne Stone, and that lawsuit included Betty Bourne as trustee of the Bourne Trust.
but TJ Leasing does not own this collateral. The collateral are units of membership in TJ Leasing. Those are individually owned assets, correct?
Yes, the Bourne Trust owns 51%, and Todd Bourne, later Todd Bourne Trust, owns the other 49%, and the membership interests are what were pledged. But,
Individually.
yes, but it is also true that when the lawsuit was filed, which is a part of the objection in this case, it included TJ Leasing filing the lawsuit as a co-plaintiff.
The letter itself was on behalf of Bourne Trust, though, correct?
Yes,
So
the
it
council
made no-
letters.
It made no representation that it was on behalf of either Todd Bourne or TJ Leasing.
That's right.
So at that point, there was no objection by those 2 entities or parties.
Well, there was an objection in the sense that TJ Leasing was in the lawsuit that was filed 1 or 2 days later, was a co-plaintiff at that time.
I think the focus was on the letter. The letter itself didn't include Todd or TJ.
That's right. The letter was written on behalf of the Bourne Trust.
And we have 2 individuals here pledging collateral as guarantors of a corporate debt, basically an LLC debt, correct?
Yes?
Can one member, the Bourne Trust, object to the strict foreclosure of another individual's collateral?
Well, the record in this case is that the creditor submitted separate demand letters,
Now,
separate
my
declarations.
question is, can one guarantor object to the strict foreclosure of another guarantor's collateral?
Well, that guarantor voluntarily surrendered its collateral.
I understand, but my question is, legally, is there any basis upon which one guarantor can legally object to the strict foreclosure of another individual guarantor's acceptance of the strict foreclosure?
Well, if they couldn't, what remedy then did my client have would be a question that would occur to me, because Sharon was making a demand on her son to surrender his collateral. And so we were doing the only choice we had with all the authorization we had.
I understand that, which was going to lead me to the next question of if you did, I'm jumping ahead, if you did redeem the whole note, what happened to the other collateral?
The 49% that was surrendered?
Because Todd didn't assign that to your client. You can't redeem another person's collateral, can you? I mean, the problem we have here is everyone's treating this as if the debtors were pledging their assets. But what it was is the guarantors were pledging their assets individually.
Exactly. Yeah, that's right. And
so really, you only had, I'm trying to help you here, the only thing you had legally to deal with is your client's John Bourne Trust collateral. That's the only thing that Betty had any say-so over, or that she could redeem.
she had 51% of both of those entities. Right. But the court did not, at the trial court level, did not take into consideration at all what the impact was of the surrender of the 49% by Todd. That was never addressed, even though we were at summary judgment at that time.
Was there a record in the summary judgment motions that would have allowed the court to make that determination? For example, were there undisputed facts about value of Todd's interests, or any way for that to have been accounted for? Do we know that his interest wasn't zero?
Say it again?
Do we know that his interest, the value wasn't zero for his interest?
We don't know if it was zero or 49% of the outstanding balance. The record did not reach that point. There was no undisputed facts one way or the other.
So did you argue that summary judgment was inappropriate at that stage on those points?
There were cross motions for summary judgment, and we argued that we were entitled to summary judgment and we were entitled to a credit of 49% against the balance due on the TJ leasing note.
But neither side in the case put any evidence in the record about what the actual value of that 49% was.
That's right.
And that's a two-part equation. It's not only the fact, like the district court relied upon minority shares can have a discount, but secondly, we don't know what the value of the company is. We know that the TJ Leasing bought $825,877 worth of equipment from Sharon Bourne, but we don't know what other assets that company had a year later, or whether they had doubled the value of that. So I don't understand how you had undisputed facts under which a court could grant summary judgment for either of you.
Well, I agree with that point, that if you're going to take the position that the creditor, Sharon, did not then have to return the 49% if the amount was paid in full, that would be true. If we were going to get a credit for 49% or a credit for some amount for the value of the 49%, the record is wanting for valuation evidence with regard to that 49%.
And who would she return the 49% to?
Well, she could return the 49% to either TJ Leasing, and it could own its own membership, or she could return it to the person that was remitting the redemption price, Betty Bourne
Now
Trust.
we're back to my original question. That would mean that your client was obtaining Todd's ownership by virtue of redeeming, when Todd himself had the right to redeem at any time.
Well, until he consented and surrendered his membership interest. Then at that point in time, it seems to me he lost his right to redeem.
Counsel, you're out of time. Would you like 60 seconds to wrap up? And during that time, if you could tell us what you're asking the court to do for you and your client.
I want you, Justices, to find that Betty Bourne timely objected, has not consented, and that KSA 9-620 does not couple objection with redemption. Those two things are not both required if there is an objection, that she has adequate remedies. And then I also want you to find that this tender that has been declared ineffective by both lower courts really has been waived or not required by the creditor on the grounds of futility. We say we've been relieved of that obligation because repeatedly counsel for the creditor said, you have to just go through the motions, but you know we're going to reject it. It was very clear that if no matter what amount we tendered, we were still going to be in court. It was never going to be accepted.
Isn't that a subjective viewpoint? Again, are we ready for summary judgment on that point?
Well, I think there's plenty of room to find that that is a question of fact as to whether or not futility applies.
Thank you, counsel.
May it please the court, my name is Todd Shadid. I represent Sharon Bourne, the appellee.
Mr. Shadid, we actually have 4 documents here, do we not? We have note number 1 and the corresponding pledge agreement, and we have note number 2 and the corresponding pledge agreement, which are in essence security agreements in the parlance of the UCC, correct?
Correct.
Where in the notes does it preclude Sharon Stone from accepting payment on those notes?
Well, it doesn't preclude her from accepting payments. There was a right to prepay, the debtor had the right to prepay the notes at any time, and they had an obligation to make annual payments.
In fact, there was a prepayment of $375,000, and she accepted that.
On the note number 1, yes, that is correct.
And the way I read it, it has some events of default.
Correct.
It doesn't say they're exclusive events of default, just says events, but then it says in the event of one of those defaults, you can have acceleration.
Correct.
And when you accelerate, that the effect of that, that the note shall become and be in default, matured, and immediately due and payable.
Correct.
It doesn't say collateral shall be immediately forfeited. It says due and payable. So when the debtor is willing to pay off the note, why are we talking about collateral? Collateral has nothing to do with nothing except securing payment, to make certain that payment is made. And when you have the debtor offering payment, why are we even talking about collateral?
Well, I would back up and look at the overall transaction and see how it was structured, because you'll see in that note, an event of default does not include failure to pay. The event of defaults are specifically agreed to, tied to either the death of John or Todd Bourne or the failure of the business, whether it's a receiver, bankruptcy, or the operation cease. You look at this, how the closing went. There was no money paid up front. First payment wasn't due for a year. So the way they structured the transaction was the purchaser controlled all the cards. If at any time this business failed before payment was paid off, if you combine the note with the pledge agreement...
But you don't combine the note. This talk about the note. My question was, what in the language of the note would preclude the debtor from paying the amount that was declared to be accelerated?
Nothing. And she had, and the debtor had the right to do that under both the note and the UCC.
But your client refused to accept payment.
My client took the position that they would not accept it, but they had the right to tender it. That's the issue. The issue isn't whether Sharon Bourne would accept it. The issue is really the step before that. Did the debtor have the means, was the debtor ready, willing, and able to tender full payment? Because the choice that the debtor had upon an event of default was either to redeem or pay and get the release of their collateral, or if they thought that the business was not worth what was left to be paid, then all Sharon could do at that point on an event of default was accept the collateral. That was the way the deal was structured, so that it gave the purchaser the option of saying, I don't have to devote any personal assets
She couldn't accept money?
if they were willing to make that payment, but if they refused to pay, her only remedy was then to go after the collateral.
I thought there was, I'm sorry, go ahead.
What language is it that precludes her from having any other remedy but accepting collateral?
Well,
Are you relying on paragraph 4?
of the pledge agreement, because I think you need to construe the transaction as a whole.
It
and-
says, you need to construe the language. It
Yeah.
says, Stone shall accept the collateral by giving notice of such fact to members, in which case Stone shall forthwith take possession of the collateral. Why does it say in which case if that's not an option?
I'm
The
not,
like, the language indicates that she shall accept the collateral by giving notice.
Correct.
That's how she accepts the collateral. And then it says, in which case, then she shall take possession. But it doesn't say shall give notice and take possession. The language itself indicates that that's an optional.
to give notice, and it says she shall give notice.
Shall give notice, shall accept the collateral by giving notice. The
And
shall is how you accept the collateral by giving notice.
Right.
And then it says, in which case?
When she gives notice.
Yeah, in which case?
Uh-huh.
So that language indicates to me that that's not the only option.
Well, I guess you could interpret it that way, but I don't think that's how the transaction was structured. When you combine it with the note itself, that excluded a payment default as an event of default.
So the intent of the party was that if John had lived 5 years and had paid $250,000 on each one of these notes, plus the $375,000 that he already paid, which was 45%. He'd already paid 45% of one note. That the intent of the parties was that Sharon then gets all of the collateral back, even if the company's worth $12 billion at that time.
No, because the debtors at all times had the right to make the payment. They had the choice. She couldn't demand payment or the stock. She could only accept the stock if they didn't make the payment. She couldn't take the stock and dispose of it and then sue for a deficiency. We don't interpret the agreements as giving her that right. She had the right to accept the collateral, and then at that point, everything was done. However, the debtor at any time could redeem or pay off the note and have the collateral released. So the purchaser, the debtor, the John Bourne Trust, controlled the cards because he wasn't investing any personal money to start this business. So if the business went downhill, if the business went out of business, or it wasn't worth what was left to be paid on the note, they could say, take your stock back, we're not paying. And that's all she gets. However, if the company was worth a lot more, $12 billion, of course he's going to pay and take the stock because he gets all the equity. But he wasn't going to get all the debt. And that was the choice that they had, and we believe that they had to then tender that money. Whether it was accepted or not is a different issue. The tendering of it was at the issue. Sharon Bourne doesn't control the tender. The tender is on the burden of the debtor or the person making payment to show that they're ready, willing, and able to make that payment. They attempted to tender because they did tender a payment, but it wasn't in the full amount, and that gets to the other issue about the 49%.
If we disagree with you, if we disagree with you that there was not a technical violation of the tender rule or whatever, that the debtors really did try to pay, and there may have been a dispute as to the balance on the note, which apparently there was, but they tried to pay the note, then where do we go? Then what's your position for why you get the collateral if she did try to pay?
I believe, and this may not be a direct answer to your question, so interrupt me if it's not. If there was a dispute about the amount owed, then the debtor had the right under the UCC to demand an accounting. They didn't do that. If they had done that, and you'll see in the Emmons case, if they had done that and Sharon Bourne refused to give an accounting, then you can argue they didn't have to tender at that point because the creditor didn't provide the information to enable them to tender.
That's just telling me that this wasn't right for summary judgment.
Well, I don't...
As if there was an accounting that needed to be done, because they were in court and they were making the argument that they owed what they tendered because of the 49%. So, I mean, they were in court where all of that accounting could take place.
But that assumes two different issues. One, when they made the payment, they didn't provide an accounting or make separate payments. They sent it one check for a total amount and say, this is payment in full on both notes. That's one. Secondly, the collateral itself doesn't get credited against the note until it's disposed of, liquidated, proceeds are applied. That reduces the note. The collateral hasn't been converted to proceeds. The collateral was 49%, but if you look at pledge number 1, the collateral is defined as all the membership units. And both members signed that single pledge agreement. So Todd Bourne and the John Bourne Trust both said, we are pledging our units as one. That's the collateral. So even though Todd Bourne gave up his 49%, that collateral still remained collateral, subject to redemption by the payor. And if it was the trust, that collateral gets released per the terms of the pledge agreement and per Article 9 of the UCC. That collateral goes back. Now, if Todd wants to take the position, well, that's my 49%, there's a right of contribution or indemnity for making the payment on behalf of him. So that collateral does not get credited until it's converted to proceeds. And I don't think that leaves it as being a question of fact that wasn't right for summary judgment. I think it goes back to the pledge agreement that doesn't allow this partial satisfaction of the note by giving up partial collateral. That was never contemplated by the parties. It was never, the facts that were in the record don't show that that was ever intended.
But she accepted part. If the pledge agreement said all, she nevertheless accepted a partial tender. And arguably, since it says full satisfaction, I would have been arguing, hey, we've satisfied because she accepted that collateral.
Well,
I mean, you got to have it both ways. If you're saying it's all or nothing, then how can you take part of it?
You're holding it until it's paid or not, because if it was paid, it's automatic release per the UCC and the pledge agreements.
And how do we know, the opposite question that I asked your counsel, when I asked him, how do we know Todd's value isn't zero? How do we know that what Todd tendered didn't more than fulfill the remaining obligation on the notes?
Because I don't think that's a question of material fact that's relevant to the issue, because that, you're assuming that collateral can be split. If the collateral is all the units, it's like you have a security interest in a vehicle, and the vehicle includes these high-dollar rims or an engine. And let's assume you repossess, but it's only the car, but not the engine that was originally with it because it was on a block being repaired. You don't just credit, if they're not disposing of it, the collateral is the entire piece. You don't split that single collateral based on what you find, and then and if you do, you dispose of it and convert the proceeds. But in this case, we argue she did not have that right to do so because the parties took away that right. They contractually agreed that she couldn't dispose of the collateral. Why? Because it gave the purchaser the right to control whether he or the trust wanted to buy out when an event of default occurred or when the business went under. If it was worth more, if there was equity, the trust was going to pay it off. If it wasn't, she got her stock back. If the company went bankrupt, that's all she got. There was no right to dispose of that collateral. So it wasn't necessarily a partial acceptance of the collateral or a partial tender. That was just part of the collateral in whose hands that was located at the time and then submitted.
Can we go to the issue of tender?
Yes.
Because I'm a little confused on how we're using that term.
Okay.
According to my notes, the record establishes that a letter was sent saying basically my client, Betty, wanted to make full payment and Sharon failed to meet with her and refused payment.
That's what the letter stated, but the facts that show after that alleged phone call to which she didn't return the call, there was a letter that said, my client is ready, is willing to tender the amount. There was both oral discussions in court by the lawyers and letters. The response to that letter was, we understand that you do actually have to tender, show that you're ready, willing, and able to make the payment. Even though for reasons that we've already explained, we'll reject it, you still have to demonstrate that you have the ability to redeem or pay it off. And it even was an argument saying, we thought you understood the difference because you still have yet to send us a check. And had they sent a check for the full amount, which prudent practice would be, pay the full amount, argue about credit later, but at least show that you were able to pay the full amount, because the UCC says redemption occurs upon payment of all obligations for which the collateral secures.
Let's go back to that letter, and I want to read something and then ask you to explain it.
All right.
The letter alleged that Sharon refused to accept full payment on the notes on September 22nd, 2011. Is that a true statement?
I would disagree that it's a true statement. It's my understanding a phone call was made from Betty to Sharon to ask for a return call. The return call was not made. It was never in the record or ever any testimony or admissible evidence submitted in the record that said, I left a message that said, I'm going to pay you, call me back, or that they had an oral discussion that said, I'm going to pay you, and she said no. There was an unreturned phone call. I'm sorry.
So it would be your position that that is not a genuine issue of material fact because that letter is not evidence. Is that right?
That is correct. And the fact that she says, I want to make the payment, isn't actually making the payment. The creditor accepts the payment. The creditor doesn't have any control over tender. So even if she says, I'm going to make the payment, she actually has to produce the funds to make the payment. There was a case that we cited, I think it's out of Florida, that I think both sides cited, I think the Court of Appeals cited, that talked about an attorney wrote a letter that said, my client has deposited $10,000 in my trust account, and we're willing to make the payment that we're owed. The payment was never actually made, and the court said, making an offer isn't tendering. Saying you have the money and you're willing to do it isn't actually producing the funds. So saying she intends to pay, which is no different than the subsequent lawyer letters that said we're going to pay, it's not a tender until you actually show that you can pay. Because if they didn't have the funds available, it really doesn't matter because they couldn't pay anyway.
But when Sharon allegedly says, I'm not going to accept the full payment,
right?
Why is that not a genuine issue of material fact to preclude summary judgment?
Because it's the tender that triggers the redemption. And the tender does not require acceptance by the creditor. The statute is pretty clear on this under the UCC. When you tender full payment, then the collateral is released. Whether I accept it or not, whether Sharon accepts it or not, is irrelevant. So I can get the check, Sharon can get the check. If she never cashes it, but the funds are good, she can say, I'm not going to accept it. That doesn't change the fact that they've already redeemed it, and they can go to court and say, we've tendered the funds, we've done what the statute said, which is tender, which actually means not only having the ability to pay, but actually producing the funds, and it's over. And it doesn't matter what Sharon says at that point. So her statement saying, I need you to produce the funds, even though you know I'm going to send it back, at least goes through the motions to show you had the ability at the time that you were required to do so to pay the amount in full. They did tender, so it wasn't that they never tendered and said we didn't have to. They did tender. They knew they had to tender. They just tendered an amount that wasn't the full amount, and then later claimed, well, that was because we gave credit at 49% of this collateral that you have not even liquidated, that has no discerned value, to which you don't have a right under the agreements to liquidate and sue for a deficiency anyway. It was our position. It was all the collateral is what we get, or we get full payment. Those are the two options that the parties agreed to on an event of default. And it allowed the purchaser to make the decision that if the company wasn't worth it, the purchaser did not have to pay and can give everything back and not expose personal assets to a debt. And that's how it was structured from the start. That was the intent of the parties.
But we have case law, and we have statutory law talking about the standards of the right to contract. 9603A talks about standards that are not manifestly unreasonable. You understand that? And we have all those cases that I didn't look any up, but I'm sure you're aware of them. The tact was to sell real estate on an installment contract and put in there that you had strict foreclosure rights. You terminated on one, any default, and they could pay 3/4 of, or say 45% of the purchase price, which was done here on note number 1, and say you have a default, so we're taking it all back. And we've said, no, that's unconscionable, that you can't have a penalty as a remedy. You have to have some semblance to the damages. So why isn't that comparable here, that we have a payment of 45% of the note balance within like 6 months of the note's execution, and 5 months before death, and 5 months later you get the you're construing the agreement that you get to keep all of the collateral plus the 45% paid. Why isn't that manifestly unreasonable?
Well, we don't know what the status of the company was at the time of the event of default, because the company may not be worth anything at that point. If John Bourne is the one running the company and he's gone, that company may be worth nothing. So why would the purchaser then want to pay more good money after bad? That was the whole design. So I don't think that it is manifestly unreasonable.
That same argument could be made on those cases that had the installment contract. The property may be run down, may not be worth anything. So the remedy was the courts fashioned an equitable mortgage. It says we have an equitable mortgage so that, yeah, you can take the collateral, but if there's a deficiency, you can go after it. But it didn't allow for strict foreclosure, which takes away, it eliminates deficiency,
Right.
but it also takes away excess.
Right. And I think you were relying on 84-9-603. And with all due respect, I think where you really need to look is 602, which are the non-waivable provisions of the UCC, of which the strict foreclosure statute is one of them, meaning that strict foreclosure has certain requirements that give the debtor the right to either consent or object, or if it's a consumer good under the installment contract, the debtor or the creditor must dispose of it. The 603 that you're referring to...
No, I'm not getting that. 602 has a right to redeem that's not waivable by the debtor. How does that turn that into a sword for the creditor that they can force a strict foreclosure?
That doesn't, okay? You have to go back to, I believe, 610, which talks about what rights does a creditor have upon default. They can do 3 things. They can dispose of the collateral by lease or otherwise. They can use a strict foreclosure process. Or 3, they can abandon the collateral and sue for the whole amount. And it says in that statute, may. And if you look at then 602, 610A is not listed in 602, but 610B is. So what that tells you is, if the creditor decides to dispose of the collateral, it must, under B, 610B, do it in a commercially reasonable manner, and that cannot be waived under 602. So if you look at those statutes together, and then look at the parties' agreement, and look at the statute that allows, I think it's in Article 1, that allows everything to be varied by agreement unless expressly stated otherwise, which 602 is otherwise, the parties can contract around the 3 options.
Where are you getting that? Because 601 says after default, a secured party has the rights provided in the UCC in addition to those provided in the parties' agreement.
Right. So I will go with, starting with, first we start with basically the structure of the UCC, which is a flexible statutory scheme that allows commercial expansion through the parties' agreements so that it doesn't have to be amended all the time. So it has flexibility to be interpreted as broadly or as narrowly as the case may be. That's one. And then you look at, I believe it is 84-1-302 of the UCC, and it says, except as otherwise provided elsewhere in the code, the effect of provisions of the UCC may be varied by agreement. 602 is the provision under Article 9, which basically says all provisions under Article 9 may be varied by agreement except those listed in 602, and only to the extent that those provisions provide rights to the debtor or obligations to the creditor. So if
We're
you-
talking past each other, I think. The 601 says a secured party has the rights provided in UCC,
Right.
in addition to those in the agreement.
Right.
I read you the agreement. It said what rights were in the agreement with regard to the acceptance. Where does it say, that agreement say that the rights of the creditor here were only under Section 4?
May I grab
Are
my
you
book
saying
real
in
quick?
paragraph 4?
Yes.
And if I interpret paragraph 4 as not saying it waived all other rights of the secured creditor under the UCC, then what I'm saying, if that paragraph does not waive all other rights, it says what her rights are with regard to acceptance, but it doesn't say it waives all other rights of a secured creditor.
You're right, that paragraph does not
And if it
say-
doesn't waive all the other rights, 601 says then she has all of those other rights. And if she has all of those other rights, that torpedoes your whole argument, which is founded on the fact that she only had one right.
If you isolate paragraph 4 of the pledge agreement and not construe the documents together, I would agree with that statement. But I believe if you construe the transaction as a whole by looking at the purchase agreements, notes 1 and 2, and pledge agreements 1 and 2, you arrive at that conclusion because of the way the transaction was structured. But if you isolate paragraph 4 and kind of read it as if you did, you could say, well, it says she shall give notice, in such case she will get the collateral,
Well,
which,
like on note number 2, there's a way that it's structured. It's very, very common. If somebody dies, I want the shares of the stock of that company back. I mean, that's a common scenario because I don't want anyone else running it. And so you have a stock repurchase agreement. You don't rely on a creative interpretation of contracts or the UCC.
No, usually-
And that wasn't done here, was it?
no, but usually the restrictions on stock are found in either the bylaws or the operating agreement that says in the case of death, the owner must dispose of it or the other person has the right to buy it. You usually don't find that in the note itself. Those restrictions are restrictions in the operating agreement or bylaws.
Can I ask you one quick
Absolutely.
question? I know we're way over time here. Paragraph 8 of the note says, this purchase price note contains the entire agreement among the parties. So, given that, how can we modify the plain language of the promissory note that says upon acceleration it's just due and payable and doesn't say anything about other remedies being exclusive? How can we modify that through the pledge agreement?
Well, I believe the law in Kansas is when agreements are executed together and part of an overall transaction, they're construed together. And I know it has an integration clause in the note, but I don't think you can then say, well, in that case, you ignore the rest of the agreements that you signed at the same time, a
They
part of the
weren't
overall
signed
structure.
at the same time. Note 1 in the pledge agreement were September 30th, and Note 2 in the pledge agreement were October 1st.
By their date, but they were overall, it was the overall same transaction at the same time by the same parties. It was the overall scheme of the
It's
entire.
not the same parties. You have, Todd's not involved in Note 2.
No, you're right. Technically, there are different parties, but the owners of those parties are all the same, and it was one transaction. And I don't think there was any dispute to that. And for proof of that, look at the letter that was sent by Betty Bourne when she submitted the check. She should have submitted 2 checks. She submitted 1. And so she didn't treat the parties as different at the critical time of tendering payment. None of the parties did. It was set up, except for the notice that Sharon Stone sent. They treated them separately. But every other juncture, it was one overall transaction. So you construe that transaction as a whole and not pick one provision and then, go with it and then create a situation that wasn't the overall intent of the parties. But I agree with what you're saying. In reading that paragraph 4, you could get to that conclusion, and the only argument I would say is you have to look at the transaction as a whole, and hopefully you don't get to that same conclusion when you do that.
In terms of the formation of these agreements, how was your client involved with those? I noticed that it was Bourne Trust Council that drafted the provisions of the agreement. What role did your client have in the formation of these agreements?
They weren't negotiated. They were
That's my question. So,
they were not negotiated.
The family hired counsel to create this transaction.
John
and-
Bourne, John
Go ahead.
Bourne's counsel, who he had, created the documents to structure this transaction to purchase into Bourne Stone.
Okay.
That was the structure. She was looking to sell to her cousin and keep it in the family.
Right.
He brought his attorney to come up with a transaction that saved taxes, that didn't cost money up front, and they structured it this way. They drafted the agreements.
And also to secure her interest.
Secure her interest, but limit, we argue, the remedies she had upon default so that it protected John Bourne or his trust if this business went further downhill
So
and was no
she
longer...
had no independent counsel to look
Correct.
at this and to determine whether or not her interest was indeed secure in the way she thought it might be.
Correct.
Perhaps.
Absolutely right. That's absolutely correct.
Thank you.
Thank you.
Thank you, counsel.
Thank you.
And perhaps you could follow up on that inquiry. Does that make a difference here, that she didn't have counsel and that your client was basically the scrivener of this deal? Should that be then strictly construed against Bourne Trust and John Bourne?
I think that's what's been argued by the defendant throughout, and
What's
it
your
is
answer?
true.
What's
It is
your
true.
answer?
Yes.
Okay.
Counsel, what reason, if any, was articulated by Sharon to Betty when Sharon essentially said, "I'm going to reject any tender that you make"? Was there any reason articulated?
Not that I know of. One of the differences here on this notion of tender and rejection that has not been articulated yet is the fact that none of the cases that counsel has talked about concerning the obligation to tender, in none of those cases does the reported record or the decision disclose that the creditor was saying, "I'm not going to accept it. You have to go through the motions. You know we're going to reject it." The South Fork case that he referred to in his argument has none of that language in there about the creditor saying in advance, "We will reject it, we won't accept it." So I think that's an important difference. We also think that, as noted by some of the questions, Sharon did not have only two options, as I think the Court of Appeals indicated, namely accepting full payment of all the obligations or strict foreclosure. The UCC, I think, discloses that she continues to have the option of disposing of the collateral in a commercially reasonable manner. That option still exists, even though it was not in the document. It's a non-waivable provision under the UCC, and we think that still exists. Any other questions?
Do we have any further questions? I see none. Thank you, counsel. Thank you both for your arguments this evening. The court will take this matter under advisement. We now turn to the second case on this evening's docket. It's case number 109995, State of Kansas v. Dante Patterson.
May it please the court, Richard Ney appearing for the appellee and petitioner for review, Dante Patterson. Excuse me. Mr. Chief Justice, I'd ask to reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
Your Honors, the issue in this case simply is, does a warrant to search a house, and a house alone, give police the right to search any vehicle they find in the driveway of that home? The Court of Appeals says yes, contrary to the district court.
Well, counsel, let me interrupt you there. Is that what the warrant said?
I'm sorry?
Is that what the warrant said?
The warrant?
That the warrant told the law enforcement, you can search this home?
Yes, the warrant strictly was limited to the home, to the premises was
Okay,
the
well,
term.
but isn't
Yes.
that different, though? Isn't premises different from home?
Well, under the case law, it's clear that we consider premises the home, the curtilage of the home.
I just wanted to clarify that. You started your argument saying the warrant was limited to the home, and that's not my understanding of it.
Okay, well, the premises, as has traditionally been held, includes the curtilage of the home. But it has not been held to include vehicles or persons. In fact, the warrant itself, at the end of the warrant said, you're commanded to search the above-named premises, conveyances, or people. And no conveyances or people were named. So the police get to the residence. Some of the officers go inside the house. Another officer, Officer Groh, immediately goes to the Mercedes in the driveway without knowing whose it is and begins searching based on, as his testimony was, on the authority of the warrant. That was the officer's testimony.
What does the record show? Wasn't there was a child sitting in the car?
There was a 14-year-old male sitting in the car, yes.
And that person told the officer that the car belonged to his dad, right?
Yes.
And the dad was named in the warrant?
I'm sorry.
The father was?
No,
his-
no person was named in the warrant, Your Honor.
Okay.
He was mentioned in the application, as were
That's
the
what-
other
excuse me,
residents.
The application.
Right.
He's named in the application.
I
Counsel,
think actually the juvenile.
Before you go any further
Yes.
on that, I wondered if you could spend a minute and give the facts of this case so our audience knows what was found. I know we've been talking about the legal issues here, but if you could give a little bit of background, that'd be very helpful.
Certainly. When the house was searched, basically nothing of evidentiary value was found. There was, the officers testified there was enough marijuana residue that perhaps you could roll one joint. So the warrant itself for the house was a bust. In the car was found cocaine and other manufacturing or drug-related paraphernalia. There was in clothing in a basket inside the car. And really the proceedings here, the case here is proceeding against my client based on what was found in the car, although one of the counts relates to the house as well, some cash that was found there. The Court of Appeals, in reaching its decision in this case, relied basically on the curtilage argument, which is not, and the Court of Appeals, and I certainly agree with this part of their argument, or their opinion, was that this is a novel question in Kansas, with the exception of one case, State versus Coker. And in the Coker case, in 2003, another panel of the Court of Appeals found clearly that a visitor's car in a driveway, when search warrants are being executed, does not give the police the right to search that vehicle.
The factual distinction's pretty compelling. It was parked in between the house to be searched and a business that had public parking.
Right, there was a driveway between the two,
Right.
Your Honor.
And so it was parked in a position that was between the public, access to the public and the private drive. And the other distinction, I believe, didn't that warrant mention vehicles?
It says they could search any vehicle they came
Okay.
across. And I would say, Your Honor, of course, Your Honor was on the Coker case. The difference there is it's really a difference without any kind of real difference. If you say, don't mention any cars, or mention all cars, it's the same problem. The requirement is specificity, the statute, and of course, the constitutional provisions, but the statute 225202 requires specificity for the search of persons, places, or vehicles, conveyances. And that wasn't included either in the Coker search warrant or in the search warrant here. There was no specificity. Indeed, if the court or if the state, the prosecution, believed that my client's car was of significance, they could have gotten a warrant for his car, found out what car he was driving and searched it. But again, as the facts proved in this case, Mr. Patterson was not a resident of the house. He was a visitor, visiting his son. His son lived with his son's mother at that residence. So any more than any other visitor. But we look at the line of case law, we look at Ybarra, the United States Supreme Court has been clear that just being present when a search warrant is executed does not give police the right to search. We cited, besides Coker, which we think is significant, cases from other jurisdictions have held the same relating to vehicles. In fact, Justice Johnson in Coker, your panel there wrote, therefore, the concept of curtilage should not function to bootstrap the search of a visitor's vehicle via that portion of the search warrant which describes a residence. That's the case here. I understand the difference, but in the Coker case, both the residence and the business were being searched. There was a search warrant included both the residence and the business. The driveway was in between the two. And the person who arrived was the mother-in-law, and her vehicle was searched.
Is there any question that you have that the vehicle was not within the curtilage of this particular premises that was?
Well, it's an interesting question.
Well, yeah, what's your answer that it was not? It seems to me that a car, a vehicle that is backed up to the garage, within 2 feet of the garage, satisfies the factors that we look at in determining what is within the curtilage and what isn't. Well, if this was a trash pull and they went up and took a trash pull, that means getting into the trash of someone's residence. We've kind of said something out near the street, not within the curtilage, something maybe closer to the home is, and it's protected there. So where's this particular vehicle at?
The vehicle is in the driveway.
Within 2 feet of the attached garage,
Yeah,
correct?
within a few feet.
Right.
But this driveway is a very short driveway. If you look at the photograph that was an exhibit here, the front of the car was basically at the end of the driveway. And it's interesting you mentioned a trash pull because they had gotten the warrant in this case from doing trash pulls, and they described the location in the application of where the trash was about 3 feet or so where from the front of where that front of the vehicle would be. So it's a very fine line of curtilage, if you will.
It's a perversity of the case, too, because usually curtilage is being invoked
Right.
to talk about the area of privacy that can't be invaded without a warrant, not the area that you can invade because you have one.
Exactly.
It's the flip side,
It certainly is.
which makes me wonder if curtilage is even the right term for what we're trying to figure out here.
And I think the Coker case would tell you no, and the cases we cited from Texas and the federal district court from Arkansas would tell you no. Baserta, which is sort of the key curtilage case, as we know, only talks about property. Curtilage as being property. We don't talk about people or automobiles as part of the curtilage because they move. That's the whole point. Now, if this car had been in the garage, that may be another argument. But this car was out of the garage where a visitor would park. There was, if you're visiting this house, there's basically one space for one car in that driveway.
Is that the distinction you would draw if comparing this to any other container that might be on a curtilage? Is mobility, is that?
Well, it's not a permanent part. When you talk about curtilage, you're talking about property.
But what if this was just kind of a bunch of stuff that was leaning up against that garage? Almost a lean-to shed type of thing.
Well, I understand. And shed would apply to Baserta, which would say, yes, that's part of the curtilage. But a car, especially a visitor's car, and this was a visitor's car, comes and goes. People come and go. I don't think this court would say, well, the people were on the curtilage, so we could search them. Ybarra doesn't apply somehow because we're going to say curtilage concept defeats that.
How clear is it that he was a visitor? I mean, wasn't in the trash pool, didn't they find utility statements in his name?
Well, the trash pulls were in September, one of the first ones, and then in November. The police said that there were articles that linked him to the house, but again, it was his son and his son's mother living there. But if you look at the record, when I questioned the motion to suppress, and this is volume 4, this would be about pages 50, 51, did you find any documents there, mail, what have you, linking to my client? No, except the title to the Mercedes was in a drawer with some women's hair curlers and things of that nature, like stored. Did you find any male clothing, adult male clothing? No. They produced nothing to show that he was a resident. And in the preliminary hearing, which is volume 2 of the record you had, the police, in fact, testified at the preliminary hearing that he gave another address, and he was there just visiting his
But the
son.
application for the search warrant in this case painted him as a resident of that
Well,
house.
it did.
And you're
It
not
did or did
challenging,
not?
sorry.
I'm sorry,
What?
it did or did not? I didn't hear.
It did name him as a resident there. And yes, I am challenging that.
Have you challenged on appeal the reasonableness of the warrant itself? You're not challenging the issuance of the warrant.
Well, we raised 2 motions. The court denied the reasonableness of the warrant based on probable cause. But the state has the burden of proving the validity of this search, the one that's
I
before this
understand,
court now.
but does the state bear the burden of proving the validity of the probable cause that supported the warrant when the state prevailed on that issue below?
Now, the argument was he a visitor or not? And the state, in fact, if you read the argument, counsel for the prosecution says, well, Mr. Ney hasn't put this on. Oh, well, it's actually our burden to show he was a resident. But there's questions about whether they found clothing, articles of mail, anything, which I asked the officer about. And they said they found nothing. And that the previous testimony had been that he did not live there, as he testified to.
You're not alleging here on appeal that that the state had no probable cause to support the warrant.
That's not the subject of this
appeal, right?
Appeal. In fact, it's the state's appeal, of course.
Right, and the argument is over the scope of the warrant. Essentially, I'm boiling it
Yes,
down.
but the Court of Appeals somehow tried to bootstrap or create this nexus between the defendant.
Well, counsel, and the reason that I can see that being relevant is if we are going to follow Justice Byers' suggestion that maybe curtilage is the incorrect legal rubric through which to view this case, it would seem to me we would fall back on the touchstone of Fourth Amendment law, which is simply reasonableness. And I guess the question of mine to you then is, why wasn't this search simply reasonable, given the facts that the officers had at the time, which were that they submitted an affidavit, that there was probable cause, that Mr. Patterson was a resident of the home, they find the vehicle parked up right next to the home, they obtain information that the vehicle belongs to Patterson. Why isn't that search reasonable, just like any other search of any other container on those premises would be reasonable?
Well, because the Fourth Amendment and the statutes in Kansas apply to particular description of things to be searched. Could the officers have said, okay, now we've got a car here, but the search was going on before they knew the car belonged to Mr. Patterson. Eventually, they do have the conversation with the 14-year-old.
That goes back to my question, when did
Right.
that conversation occur?
I think it's unclear from the record.
Okay.
And the
But
Court of Appeals...
the young man, child.
Right.
Teenager,
Teen-
was sitting in the car. So once they're searching it, presumably they've had to either remove him from it or ask him to get out of it. There's conversation occurring right then.
But the officer testified he was going to search the car based on the warrant, and he did, without any connection to that. And the Court of Appeals, I want to point out, at the best they could say, and this is from the last page of their opinion, says the way the car was in the driveway, the manner it was parked, its nearness to the house, all suggested that the car belonged to a resident. I don't think that's sufficient. I don't think we can create a search warrant for premises and then say it applies to whatever we want it to once we're on the scene. And without the particularity that's required under the Fourth Amendment and Kansas statutes.
Counsel, I see you're out of time. Would you like 60 seconds to wrap up, or do you
I
think
will-
you've made your points?
I'll reserve my time.
I do have one question. I'm still puzzled about, yeah, get back up there.
I'm sorry?
I'm still puzzled about whether there is a legal difference between this being an automobile and whether this had been a trash can, a closed trash can, and the police looked inside the closed trash can.
Well, there is, and I think the difference is both under the Fourth Amendment, as I said, jurisprudence, but under 252302, names 3 things that a search warrant must describe in particularity: a place, a person, or a means of conveyance. It doesn't talk about trash cans. And I think the case law has encompassed things like trash cans or sheds into the premises concept, the place concept. But it clearly is a distinction between conveyances, which can come and go. And I think that's the difference. Visitors do not come with their trash cans to someone's residence, but they do come with their cars.
So is that a statutory argument or a constitutional argument?
It's both. I think the statute here was a codification of constitutional concepts of what has been required particularity and description. So it's truly both.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Good evening once again, Your Honors. My name is Lance Gillette, and I'm the Assistant District Attorney from Sedgwick County on behalf of the state, the appellant in this case. As a preliminary matter, as the court may note, I was not on the brief. I'm arguing this on behalf of one of my colleagues. I think that I would start off with just the general principle in this case, that what is it about this case that would necessitate a departure from decades, literally in this instance, decades of jurisprudence? And the answer is nothing. If we start with the line of cases that the state has cited in our brief with Basurto, which was specifically adopted and affirmed by this court, a search warrant which describes a specific residence to be searched authorizes the search of that residence and any other structures, buildings, or vehicles located within the curtilage. Case law is replete with other examples, specifically from the 10th Circuit.
That case did involve a shed, didn't it?
Basurto did indeed involve a shed.
So it's arguably dicta, its reference to vehicles.
I think that there's at least some argument that can be made that it is dicta. However, I think that the general principle stands in that when a search warrant is granted, it is for the entire premises and all of the containers thereon, and that would include a shed, that would include vehicles.
How do you respond to counsel's argument about the language of the statute differentiating between places and conveyances?
I do believe that there is a reason for a distinction here, but I think that ultimately when it comes down to, in this case, is that it may be a distinction without a difference. When there's probable cause to search a location, and the fact that within that premises a car may be located, it's arguably reasonable to assume or to conclude that that vehicle may actually carry away evidence of a crime, or it could actually contain therein, could pose a danger to officers. And so while there is a delineation made within the statute, I think that the case law itself properly interprets the intent and the merits as it regards to Fourth Amendment and the protection from unreasonable searches and seizures. I think that it is reasonable to search a car that is on the premises.
That argument does seem to go to a per se exception that would allow a search of any vehicle. And the case law certainly isn't that broad. So I don't know that we can accept that as almost a exigency sort of circumstance that would create an exception.
And I don't mean to, and if I was unclear, I meant to indicate that a vehicle that is on the premises, and that premises, then we start to roll into our curtilage test, whether the vehicle is so closely associated with the home that it can be considered as part of the premises. For instance, I understand Your Honor's concern, and we certainly would want to stop individuals from the community that would just happen to be driving by while these officers are executing a search warrant. Perhaps they are even curious and might stop across the street and attempt to watch.
Or if they stop in the driveway?
Well, then I think that you have a couple of issues there. And if I understand your question, are you asking whether or not I think that we could search their car?
Right. If you have a search warrant for the residential premises.
Right.
A stranger pulls in the driveway, say they're going to just back out and go the other way, and they are on the curtilage, that's sufficient nexus to the residents to allow that search.
It would depend on the interpretation and the specific facts of the curtilage. And I think that's...
I'm hearing you say that the curtilage includes vehicles that are contained within that boundary, within that area. Did I misunderstand you? That was sufficient, the naming of the premises is sufficient to include vehicles that fall within that parameter of the residence?
Within the premises, yes. My point in drawing a distinction here is not all driveways are the same. For instance, a rural driveway where you may have someone entering, quote unquote, the premises a mile or so away from the actual home is obviously different than this case.
Let's get away from that. Let's say, let's say that it's a driveway which would be within the curtilage if it were a shed. Okay?
Sure.
All
If they pulled up to that degree within the curtilage, then possibly is the best
Even
answer
if
that I
they're
can
just
give.
driving by? Even if they're just driving by? Because that really is a kind of a blanket exception.
Not if they're just driving by.
Okay.
If they drive in and pull all the way up to the house as though they live there, own the house, then possibly. The statutes, I believe, do provide that individuals can be stopped during the execution of a warrant. Now, there are some questions that arise that are not relevant in this case as to whether the arrival during the execution of the warrant may create some exception there as well.
Let's deal with this case. We've got two cars, right?
Yes.
From the photographs that are in the record, there's a car parked on the curb.
Correct.
And then there's a car in the driveway.
Correct.
You didn't search the one on the curb.
That is correct.
How come?
I wish I could answer that question because I believe that the probable cause plus exigent circumstances exception to the search warrant requirement may have and likely could have allowed the officers to have searched that car. Because as the court would note from the record in this case, both cars were actually owned by the defendant. And I have substantial dispute with my opposing counsel's description of the defendant as not a resident of this home.
Well, but I want to focus on these two cars because it seems to me that's where part of the questioning here gets us. That I can't see why, and I don't want to talk about exigent circumstances because you guys are arguing that this came within the language of the search warrant. So stick to the language of the search warrant. Why one and not the other?
And my best answer for that question, Your Honor, is that the car that was parked on the street was on a public thoroughfare. It was not within the curtilage of the home. It would not have fallen within the scope of the search warrant.
And so, are we talking about proximity to the house being the deciding factor? Or is there anything else that enters into the calculus?
There are, and that's where we get into the Dunn case. And proximity to the home is certainly a factor. The Dunn case, United States versus Dunn from the United States Supreme Court identifies 4 factors that are generally recognized by this court as determinative of whether or not an object or an item, a container, is within the curtilage.
And let's take those 4 points. Do the officers have to know the answers to those 4 points before they search, or can they back it up later?
I'll be perfectly honest, that's a good question. That's one that I hadn't necessarily thought about. I think under either circumstance in this case, the 4 factors, though, weigh in favor of authorizing the search of the white Mercedes. The proximity to the area, as we've all discussed, this car was, and I think it's important as well, the car wasn't just pulled into the driveway, it was backed up into the driveway within feet of the home, maybe enough room for a person to walk behind it. The photograph, it speaks for itself. There is a significant additional portion of the driveway for enough room for at least one more car. Furthermore, the location of this car was at the only point of ingress or egress to an attached garage, a one-car attached garage. I think that is indicative of the fact that it would be unlikely that a guest would park in this manner in that location. The second factor is whether that area is included within an enclosure surrounding the home. In the instant case, there was a fence, albeit without a gate. There was a fence. The car was within the fence line. If we were to extend that fence line across, the car is well within the fence line to the degree that the Court of Appeals noted that, quote, at the very least, this placement suggests that the car belongs to the household. Again, not the way a visitor or an innocent bystander may park. And I would just remind the court that the fence itself has meaning, and it's really twofold. It delineates an area even closer to the home over which that homeowner desires to associate with a higher level of privacy, and it also keeps people out of that area. So the fence does have significance here. The third done factor was the nature and use to which the area is put. We're talking about the top of the driveway. This car is all but backed into the garage. Now, the cars, as we've talked about, they do transport people, obviously. They're mobile. However, cars also store items. I don't think it's beyond common sense to realize that we all store items in our cars. We carry things in and out of them every day. They transport things to and from our homes. In this instance, the officers were searching for drugs. This was a narcotics search warrant, and I believe it included firearms. Drugs move. They have to move somehow. They come and they go, as do their proceeds. And in this case, there was over $10,000 in cash alleged to have been drug proceeds stored in the master bedroom of this home where the defendant was located. But again, going back to the car, it's his car.
Do the officers know it's his car before they go in?
To that end, I don't know that they knew that he owned the car. I think that it was very reasonable to conclude that the person that owned that car lived at the home. When they were approaching, they saw the defendant's son, and they identified him in the driver's seat, just sitting in the car as they approached. They knew who that was. They knew it was the defendant's son. In fact, the defendant, the son that was removed from the car, and one other individual that was ultimately located in the basement of the home were all named in the application for search warrant. So this was very specific as to where and who we were looking for. Again,
if the law enforcement officers knew that this particular person was the target of their drug investigation and their drug search, and they have the capability to find out what vehicles are registered to that person, and as you said earlier, it's only common sense that drugs might be stored in the vehicle, then why isn't the remedy for law enforcement to take that next step and say the residence and this vehicle and this vehicle?
Are you asking if we should have named it specifically at the very beginning? I don't know that there's a reason that they couldn't have. It would have been additional investigation certainly would have been necessary.
And I think that's what counsel's trying to argue, is that our Fourth Amendment jurisprudence is that you need to name with particularity what you intend to search, that it doesn't give you carte blanche just to go willy-nilly through whatever you want, and that if they had the means to name that vehicle in the warrant, why is it reasonable to let them search it when they just didn't take that step to do it?
I don't know that I honestly don't know that they had the means in this particular case. And the other side of that is that we're talking about something that's happening very quickly. In this instance specifically, it was a no-knock warrant. Again, cars move. It may or may not have been there. They may or may not have been able to find the car, even if they had specified it in the warrant at the time. And the Fourth Amendment jurisprudence, actually, the state believes is fairly clear that a car on the premises can be searched, as with any other container on the premises, for which there's probable cause to search.
Counsel, were you going to go through the fourth done factor before you sit down?
I will. I'll briefly address that. Thank you, Your Honor. The fourth factor were the steps taken by the resident to protect the area from observation by people passing by. Again, this car is backed in, pulled all the way up to the house. And in order to have even gotten close to this car, you would have ended up going up the driveway towards the garage and have been immediately next to the home. And I think that touches a little bit on what Justice Beyer pointed out. There's an interesting twist of the case in that he's not claiming privacy here. And the trash can analogy comes in again here as well. I think if the roles were reversed, if these officers had just gone up and started perusing around his car at the top of the driveway right next to his house, we would have seen a completely different search warrant, one where we would have been alleged to have invaded his curtilage and invaded his privacy, violated his rights. So there's a bit of a catch-22 here. And I also think it's interesting to note that some of you have asked about the trash cans, when they're next to the house, they're given basically the same protection as the house. When they're by the curb, they receive a different level of protection. I see it similarly with a vehicle, which is traditionally under Fourth Amendment jurisprudence given some of, if not the least amount of privacy of any container or item that's personally owned. I see no reason in logic to treat that any differently than we would treat or with any higher level of scrutiny than we would treat a shed or a trash can.
Does that mean then that you would disagree with the next step that the Court of Appeals took, which was to apply the Tenth Circuit's decision in Gottschalk and require some showing of indicia of control or possession by the occupants of the premises over the vehicle?
I don't think that the Tenth Circuit's Gottschalk point of establishing ownership is necessarily unreasonable. I do not, though, see any reason to change what has been the standard practice in Kansas, as I've mentioned before, for decades, which is the residence is specifically described as it was in this case, then a vehicle found on that premises can also be searched. In this case, though, as it did turn out, I think there's a strong argument to be made that ownership of the vehicle by a resident of the home was demonstrated, again, by those curtilage factors, by the fact that the defendant's son was in the car, and ultimately, I don't think that we need to necessarily turn a blind eye to the fact that the title to the car with defendant's name on it was found in the master bedroom, the same location where he was when officers entered the home.
But we don't know that that was found before they started the search of the car.
Unfortunately, we don't. We also don't know that it was found after, unfortunately.
Yeah, we just don't know, and we don't know exactly when the conversation with the child took place. So
Correct.
If I'm understanding your answer to my colleague's question, you're saying Gottschalk is nice but not necessary.
I think that's a fair way to characterize it. It's nice, but it is unnecessary.
So you lost this case at the district court level. The district court suppressed the evidence. So you appealed on behalf of the state. What's the rule of law that you want to come out of our decision?
The rule of law that the state would like to see come from this decision is that the rule of law remain as it stands, that vehicles that are within the premises can be searched when there's probable cause.
Pursuant to a warrant for the premises.
When there's a search warrant for the
And
premises.
let me just stop you there for just one more second. And that is, you keep referring to this as a rule of law, but then a moment ago you referred to it as a practice. Is it a practice that you'd like to see a rule of law support, or are you actually telling us that the rule of law already does support it?
My apologies if I said that. I believe I misspoke. I believe that the rule of law is that if there's a search warrant, then a vehicle within the premises of that target location may be searched.
Notwithstanding the particularity requirement in the Fourth Amendment or in the statute pointed out by your opponent.
Correct, and for that, I would cite, again, back to Basurto, and I would also note, this court's opinion, too many pages. The sentence was at 218 Can 750 in Timmons, and it reads, quote, "The automobile, comma, being parked in the driveway, comma, was on the premises." I think I'm even more deferential than that statement is, in as far as my earlier hypothetical about the differences amongst driveways, but that statement is fairly clear, and I think that's part of our alternative argument for the good faith exception, which we would also ask that this court consider in this case.
So if you were hosting a party at your house and 4 cars parked in the driveway because you have a double driveway, those vehicles would be subject to search regardless of their ownership?
I believe
if there was a warrant for the premises?
I believe that would be reasonable, and that's the, I guess, ultimate measuring stick here, is what we're talking about is the Fourth Amendment protecting individuals from unreasonable searches and seizures. Under those circumstances, when you've got probable cause to come search my house, then vehicles that are within my curtilage can be searched.
Why is it reasonable that the police will find fruits of a crime or whatever in my car simply because I go to a party at your house and the police have given the magistrate probable cause to believe that you have contraband? Why is it reasonable to believe my car has contraband?
I think the question of reasonableness is whether searching your car is reasonable, not necessarily whether they had probable cause to search your car, but whether a search of it, because it is on my premises for whom they do have probable cause, is reasonable. And I think that the balance has to weigh in favor of a temporary seizure and a brief search of a vehicle.
And why do we tip the balance that way when the Constitution says the general rule is that you get a search warrant with particularity?
Because the particularity, and I know this comes right back to the beginning, the particularity was as to my premises, and within my premises, you have probable cause to search the home and any containers on that property, and that would include Justice Johnson's vehicle if you had come to my party.
Have you seen his vehicle?
I have not. But I doubt he's seen mine either.
Any further questions?
One, counsel, what in your view is the purpose of the statutory listing of conveyances?
The purpose of listing it as a separate item?
Why is that even in the statute, given the rule that you've articulated that you would like us to adopt?
Because I believe in different factual scenarios, there are instances where officers applying for a search warrant may only have probable cause to get into a vehicle. I can speak, slightly outside the record, but in my experience in cases with DUI collisions and things like that, when we decide we want to search a vehicle or search the computer module from that vehicle, I don't have probable cause to go back and search the driver of that vehicle's home because there was an accident. I do have probable cause to search that vehicle specifically.
So you would interpret the statute as essentially listing a list of things with specificity that can be searched in a sort of declining order of narrowness. In other words, a premise, a home is wide, a vehicle is less wide, a person perhaps even less wide.
I believe that is correct, yeah.
Any further questions? Thank you, counsel.
Thank you, Your Honors.
Reserve 3 minutes for rebuttal.
Thank you. Let me first, Justice Breyer, answer a couple of questions you raised. One, it's only in the preliminary hearing transcript, not the motion transcript, where the statement is made that the teenager gave a statement about the ownership of the car. So however that goes. But we do have exact information about when the car title was filed. Volume 4, page 53, I'm questioning the officer who found the title, and he says it was 34 minutes into the search. And even the Court of Appeals, in its opinion, says they found it during the search of the Mercedes or afterwards. So clearly, they did not have the title before they started the search of the car.
The Court of Appeals.
The state says that jurisprudence says in Kansas you can search cars. I don't know that case. The only case even the Court of Appeals recognizes that is on that point is Coker, and Coker at least argues the opposite. And I think it's important to note we're looking at the issue of probable cause to search the car. The exigent circumstances, how you can proceed without a warrant for a vehicle, is based on probable cause.
And warrantless. You only go there if it's warrantless.
Right.
This is a warrant search.
And I think it's important, I want to take just a couple seconds of my time to read what Judge Burgess said at the time he made the suppression. He talked about this court's definition of premise. It says the term premise as used in the warrant included all property necessarily a part of and appearing to be so inseparable as to be considered a portion thereof. Quoting from McClellan as to this court's definition of premises. He then goes on to say, well, obviously, taking that language and contrasting Basurto with the facts in this case, in Basurto there's a shed, that's an inseparable part of the premises. In this case, we've got an automobile. There's no separate probable cause with regard to that automobile. It is parked outside. It was occupied by the defendant's son. It is not included within the scope of this particular search warrant. He specifically says nothing gave probable cause to the search of the car. And if you look at the application for the warrant, it was based on trash pulls at the residence. And that's basically it alone, and some unnamed informant. The point being is, nothing in the application would say that the car or any vehicle had been used for anything. And finally, the state tries to resurrect good faith here. That's not something they argued in this motion. So we ask the court to reject that, if there are no further questions.
I'd like to ask you to help me understand your argument with respect to the statute. I understood you in your previous argument to say that the statutory listing of conveyances or vehicles was merely a codification of the constitutional protection that already existed. Is that right?
Well, I don't think merely, but I think that's true, yes. The state in creating the statute was talking about what the...
So it's your position that, as I understand it, that the Constitution requires any search of a vehicle pursuant to a warrant, it requires that warrant to describe the vehicle with specificity.
Yes.
Okay. And so
Well, again, let me give this exception. If it's in a garage, perhaps, and that's considered part of the premises, this was not.
Well, but now we're back to arguing about curtilage and so on.
I think curtilage is the absolute wrong thing to think of here. Because let's concede, the car is on the curtilage. It's in the driveway. So what? People are on the curtilage. If 10 people are standing there in the yard behind that fence, and only the fence goes around the yard, do we say they can be searched? Well, your bar would say no. The U.S. Supreme Court and this court in Van Dyke are pretty clear about that. So curtilage doesn't get the state to where they want to be.
Okay, but it also doesn't get you where you want to be, which, as I understood it, was that there's a bright line rule going the other way. In other words, there's a bright line rule that any time you search a vehicle pursuant to a warrant, that vehicle better be described with particularity in the warrant. That's the bright line rule you're arguing for, as I understand it.
Yes, it is, unless something leads to probable cause to search that vehicle.
Which would be a search that was pursuant to some other rationale, not pursuant to the warrant.
Yes, and the officer's testimony here was very clear. We were searching the car pursuant to the warrant.
And so I guess my final follow-up question then is, in trying to understand this statute, it seems to me your position is that the statute does not, in fact, provide any greater protections that are not afforded under the Constitution. In other words, they're coextensive.
I believe that's true, but certainly the statute says what it says with particularity to conveyances, describing conveyances.
Any further questions?
I'm confused, so if you can clarify, because I thought you started to say that there could be a difference for a vehicle that was in a garage, but then you said, no, we're not talking curtilage. I mean, are you backing up so that we're not talking about a warrant covering a vehicle in a garage? You've changed your position on that?
I don't know that I've changed my position. I think that's not a question we have before us here. So again, if I were here on that case, I might argue that the vehicle has to be described. But if it's in a closed shed, if you will, a garage or the like, then there might be a different argument the state could make, that the warrant for the premises, including what was contained in
The premises.
In the premise.
Well, in the
Just
house.
The car is
Which you're
just a
defining.
container.
Container in the premises as opposed to
Right,
a conveyance.
right, opposed to a conveyance which is parked in a driveway.
And again, you're defining premises in that way as a building, not as the property, including land, located at whatever the street address is.
Right. I would suggest, however, that if the state were seeking to search the car, had evidence or there was probable cause about the car, that it would have to be included in the warrant. And if it became something that there's specific probable cause about as opposed to being a container, as it was a box in the garage, if you will.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this evening. The court will take this matter under advisement. This time, the court is in recess for 15 minutes.
All right.
The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. This court from recess, now sitting. You may be seated.
I'll call the third and final case on this evening's docket. That is case number 110415, State v. Logsdon.
May it please the court. My name is Shannon Crane. I'm the attorney for the appellant, Chris Logsdon, Charles Chris Logsdon. And I would like to reserve 3 minutes for rebuttal, if I may.
3 minutes is granted.
Thank you. And pursuant to your earlier request, I'm going to give a little bit of factual background so that the audience will know what happened in this case. It was a 3-week trial, so I can't go into all of it, but suffice it to say, this was a murder case in which a young woman was killed in her home. Her son was in the home with her. He was 5 years old. Someone came into the home and shot her 3 times, and the son found her, went to the neighbor's home, was able to get help, but by that time she was deceased. The state presented evidence at this trial that it was a mistaken identity, that their theory of the case was that this was a drug deal, that they were going to rob a drug dealer who was similar to the victim, and they went to the wrong house, and then they shot the wrong person. And that testimony was brought on by many witnesses from the community that testified to this alleged conspiracy to go rob this other individual over money or drugs or both. There was a lot of inconsistent testimony going back and forth about what the plan was, who was in on the plan, and what happened. But it appeared that one individual was the kingpin, and his name was Billy Craig. And he was a co-defendant. He was also charged in this case with the murder of Jennifer Heckle. And I know this is a very sad case because this woman was killed and her son was there, but we need to look at the facts of the law, not necessarily the facts of the case. And in this case, Billy Craig was central to this case and the state's theory. And it was his associates that were surrounding this case that testified in this case. And they testified that Billy Craig told them certain things. And Billy Craig, as I said, was a co-defendant. When his name was mentioned of what he said, defense counsel would object to hearsay. And each time defense counsel objected to hearsay, the state argued that Billy Craig was under subpoena and was going to testify.
When was Craig's counsel notified that the state intended on calling him in their case in chief against your client?
Well,
was this during the trial, before the trial? When, in proximity to the trial, did the state have the expectation that Craig was going to testify?
I believe the testimony at the sentencing hearing, and also there was another hearing that I supplied the transcript for in this case, and it was Billy Craig's case. It came out that there was really no conversation talking to Billy Craig's attorneys about his testimony until the trial had already commenced.
Until trial had commenced?
Yes, I believe Greg Bell was the attorney for Billy Craig, and I believe he testified that he ran into Tom Stanton, one of the prosecutors, on the courthouse steps during the trial, and Mr. Stanton said to him, you know, we're going to call Billy Craig. And that's when Mr. Bell said, well, I don't think he's going to testify.
And did that occur during, prior to, or after the assertions were made to the trial court that Mr. Craig is going to testify?
Some of them were before, and some were after.
Okay, thank you.
There were several.
Before you get started,
sorry.
Let me finish about Billy Craig. Had he been given a plea deal?
There had been a plea offer in exchange for his testimony, and then Mr. Stanton had sent a letter saying that they were not going to follow that plea offer because they don't believe that Mr. Craig had followed it, so it was revoked. And that letter went out in September. This trial did not start until October. So the state, in my opinion, knew that he did not have an obligation to testify under a plea agreement.
Why didn't the defense know that? If there wasn't any plea agreement, he had not pled, defense counsel should have been aware that it's very likely that he'll take the fifth. That would be the defense attorney's advice.
I don't believe that the defense counsel knew that, because they were different counsel. It was a different attorney for, of course, Mr. Logston and Mr. Craig, and I don't believe they were talking. And I believe that the testimony in Mr. Craig's hearing later to enforce the plea agreement, that was brought out.
Let me get that date again. The plea offer was revoked before with Billy Craig, before Logston's trial.
Yes, and I believe that's part of the record. I could find that for you, but there's a letter from Thomas Stanton to Mr. Bell stating that that plea agreement had been revoked.
Thank you.
There were several comments that Billy Craig, hearsay comments from Billy Craig, that I believe were very detrimental to the defense. Remembering the way that this case had, there was no physical evidence connecting anyone to this murder whatsoever. They didn't have a gun, they didn't have any DNA, there was just no physical evidence whatsoever. The only thing connecting all the dots in here was all this testimony from various people in the community that went around what Billy Craig was doing. And he testified, and I believe this is the most damaging part, there was hearsay testimony that he told someone that the defendant is the person who shot her. He was identified as the driver. Billy Craig was the driver of the car that went to that house, and he is the one who then identified to another individual after the murder that Chris Logston was the shooter. That was objected to as hearsay, and the state said he's going to testify, and so we'll be able to, they can cross-examine Mr. Craig, and then he didn't testify.
And which witness was that, counsel?
That was Crothers.
Crothers.
David Crothers.
And was David Crothers on the list of the limiting instruction?
Yes. Yeah.
And so why doesn't that limiting instruction eliminate any issue we have as to Mr. Crothers' testimony?
There are several reasons, one of which I don't believe it included all of the hearsay testimony that was in this case.
No, but I'm talking about Mr. Crothers. The jury was told to disregard what Mr. Crothers said Mr. Craig had said.
How do you put that cat back in the
How do
bag?
we not believe that the jury follows the instructions? Isn't that just a basic presumption that we apply?
Well, if we could apply that presumption, then you would never have to worry about whether they did or not. But we do worry about whether there is a question as to whether a limiting instruction was sufficient. And in this case, I don't believe a limiting instruction can be because of the significance of the statement. If it was that he looked like the shooter, or he may have been in the area or something, but to actually identify him as the shooter, I think is so critical to the state's position that a limiting instruction cannot make that go away. I think that's the difference of why that limiting instruction was not enough. In addition, I think the limiting instruction didn't identify all of the hearsay statements that should have been included if you were going to do it.
I think the record reflects that's correct, that the limiting instruction didn't identify all of the different witnesses as hearsay came in through. But didn't the defense have a role in drafting that instruction?
Well, defense did. Yes, they did. And
so it's not invited error?
It was not invited error because the defense did object to it. And the conversation at the time was, well, this is really hard to do, to find all of these that happened in this 3-week trial, but we're going to do our best. And that was the statement from the prosecutor and kind of the attitude that the court had. Well, we're going to do our best, we're going to try to find it, and then this is my instruction, and they're going to follow it. But when they said, you're going to disregard these 3 people, then that gave them permission to look at the other hearsay.
As to the statement to Mr. Carruthers, and actually to any of those others of the circle of friends that were, well, actually, as to anything that Mr. Craig said, why does the co-conspirator hearsay exception not apply?
Mostly because they did not happen before or during the conspiracy. These are statements that were made after the conspiracy. And my understanding is that co-conspirators, the case law is clear that it has to be during the pendency of the conspiracy, relating to the conspiracy, or in an attempt to cover it up or, to hide it. And that's
you
not
would
what was
say there
happening
was
here.
no attempt to hide this or cover it up?
I don't believe that Billy Craig telling Crothers that he's the one that shot it is in any way trying to cover this up, or this was just someone confessing or saying what happened afterwards.
And as to your issue about the confrontation clause, how are any of those statements testimonial?
Well, I believe the two that were made to the detectives were testimonial. And those two were from Detective Harcrow and also Detective Rodriguez, who also then repeated what Crothers had said. He repeated that Crothers told me that Smello, which is Chris Logston, is the one who shot her. So we have the statements to Detective Harcrow are definitely interrogatory. They were interrogating
But
Billy
they're
Craig.
coming from Crothers, right? They're
Well,
coming
those are
through
two
him?
different instances.
Well, I think it's significant, though, and you have to separate them out.
Yes.
Because the person, the declarant was Craig, and he wasn't speaking to law enforcement.
That's correct.
So it's not really testimonial.
Yeah, the one to Crothers I don't believe was testimonial.
Okay.
I
It's
think
only the
that
ones
one-
directly from Craig to law enforcement.
Correct. I believe the one to Crothers was hearsay, and it was not co-conspirator. I don't believe it falls under that exception, and it certainly didn't fall under the exception that was used at trial because he did not testify. The state brings out the fact that they tried their best to get him to testify, but that really only comes into play as if you're trying to use prior testimony and the declarant's unavailable, and that's not what we have here. I will say that the state did try to get him. They did everything they legally could to get him there to testify, and he refused. But I don't think that's relevant to this case at all, because I don't think it fits into any of the exceptions.
Counsel, go ahead.
Go ahead, that's fine. I'm going to go a different way, so if you've got to...
I was going to cut the way off.
Oh,
so
okay.
why don't you-
Well, then I do want to ask a question, because I'd like you to address harmlessness. Because
That was my
because I'm not sure that in light of your client's statement to, was it Miss Branton? That he had stayed up 8 days too many and that he shot her. And then in light of her testimony that she was part of a conspiracy that included the defendant to commit the robbery, how any of this makes a difference? Can't we just say, given his admission and her testimony, that any of this other hearsay is just add-on
Can we
and
add one
harmless?
factor? Would you accept a friendly
Sure,
amendment, Justice Lugar?
certainly.
And the video of him in the room imitating what happened.
Imitating what happened.
Reenacting the murder. It seems like
Yes.
those three facts are pretty damning.
Okay, so the three you're talking about is the statement to Ms. Branton, the video from the jail, and what was the third one?
Her testimony about there being a conspiracy.
Okay. Under harmless error, you have to look to see the whole circumstances. And in this case, we have very frail evidence. Those three things are contradicted all throughout the testimony. The testimony is just everywhere in this case. And there is reason to question each and one of those witnesses about their credibility and their history. Kylie Branton, I believe, if she's the one, has 18 aliases in Casper. I mean, there's a lot of reason to believe that if you didn't have what Billy Craig said, pointing the finger, that you could have gone after these other people a lot more effectively and said, you can't believe these people, they're liars.
Well, couldn't
But
you
it's
do
really
that?
hard.
There was nothing about the fact that Mr. Craig's testimony had come in that would prevent defense counsel from making that attack. That attack could be made anyway, right?
It could, but you have to look at the totality of the circumstances. And when you look at all of them, Billy Craig's statements are very important. The statements he makes just to get the ball rolling to police, that he knew that she was shot in the head. That was hearsay. That was ruled by the court to be hearsay and admissible under, he was going to testify exception. And all of this connects all the dots. And so if you take his big statements out of there, then the whole thing just falls apart. So yeah, you have 3 or 4 things that are damning, but you also have a lot of other things that are not. And you have Mr. Loxton throughout all of this saying, this is just what Billy Craig told me, and I am innocent, I didn't do it. So Billy Craig saying, no, he's the one who shot him, I believe is very, very relevant to this case.
And what about the reenactment of the murder portrayed by your client?
Well, that was actually done, I believe, after all the evidence had come out about how it had happened, and he was saying, this is what they said happened. He claims he was not reenacting it from his own memory, but from what the newspapers and the press had said. So I think there's a discrepancy. It makes it look like, and the state wants you to believe that that's what it looked like, but there's 2 ways of looking at that, and I believe the jury could have looked at it as he wasn't reenacting that. He was just saying what he believed happened, and that's in the transcript. That's in the record.
Put that in a timeline for us, if you could. So are you saying that was after the preliminary hearing and evidence had come out?
I don't remember when he was in the Ford County Jail. That might have been before.
And because I thought none of this had been reported in the press.
The preliminary hearing.
Until the preliminary hearing.
There was stuff in the paper before that.
That kind of detail, though?
I believe so. And he was also stating that Billy Craig is the one who told him all of this. So he was denying that he was reenacting it from his own knowledge, but from what Billy Craig had told him. And I believe a jury could have believed that, especially when you look at the totality of all of these witnesses. If you were sitting, it's 1,700 pages of transcript, and when you go from one witness to the other, and they just go back and forth about what was really happening and who was doing what and why, I think that there's a lot of credibility issues. And so I think that Billy Craig saying that, and Billy Craig bringing it all together with all the dots together, I think had a big impact in this case. And that's why I think it's not harmless error.
Any further questions? Thank you, counsel.
If it please the court, my name is Keith Schroeder. I'm the Reno County District Attorney. I guess what I want to start with is just kind of picking up on that theme, that Billy Craig wasn't the only evidence in this case. This trial took 3 weeks. I was trial counsel, Mr. Maxwell was trial counsel. We presented over 100 witnesses, more than 200 exhibits. There were a lot of other witnesses. Now, the state will concede that this was a case that wasn't full of a bunch of saints. We had a bunch of persons who acknowledged having committed robberies before. We had a lot of those problems, but we did have other evidence. First of all, we had...
How many of those other witnesses got their information from Billy Craig, is the point, I think.
None that, well, 9. I'm not sure exactly how many got it from Billy Craig.
But just because you have other witnesses doesn't negate the fact that Billy Craig's hearsay testimony is coming in.
Well, we don't believe, first of all, we believe it was corrected with an admonition. We believe that admonition, and we turned to State versus Sappington, which is a 2007 case that this court tried, and I just want to remind you about that. That was a case in which a defendant had actually 2 murder cases pending at the same time. And as there's a motion in limine to keep out evidence to the second jury about the first murder case. Or I'm sorry, I guess it's the other way around. They not let the first jury know about the second murder case. And during the trial, the state accidentally plays the murder confession in the second murder in the first murder trial. There was an admonition given. At that point, this court held that the defendant was not substantially prejudiced based on an admonition to disregard that, because there's a belief that juries are presumed to follow the instructions that, in fact, the judge give them.
That's definitely the law. We presume them to follow their instructions. But this instruction was not perfect, was it? It wasn't complete.
There were several witnesses that were left off. and I list all 5 of them. I think, first of all, the defense counsel worked in preparing this admonition, went through the transcripts and finally said, these are the 3 witnesses and we agree with that. Then what happens is, as they're going through the instruction and how the wording should be changed in the verbiage, finally they get to the point where the judge says, Mr. Brown, do you have any objections to this instruction? And after having helped draft it and talk about what should be in it, he says, well, and I guess his quote was, to be consistent, I'll object, which we question whether or not he had already acquiesced in it, but in any event, that's how it happened.
Can you help me understand why that instruction, after listing the witnesses they should not consider, it had a statement that said any other evidence about Craig they should consider? Why was that thrown in? Because doesn't that kind of count, helps the defendant's argument here today, doesn't it?
You're talking about the nature of the instruction itself?
Yes, yes. The last sentence, this instruction applies only to the witnesses named and not to the other statements you may have heard regarding Billy Craig in this trial.
I'm sorry, I can't find that. I can't answer your question. I just know that there were and you're referring to the last sentence?
The last sentence, yes.
There was other evidence involving Billy Craig and other statements made by Billy Craig, I believe, that weren't incriminating against the defendant. I can't recall exactly how that came out. But clearly the defense agreed to it. There was no objection to it until the very end, and they said that they wanted to object to it, just for consistency.
How could any statements from Billy Craig come in, incriminating or otherwise?
Well, they could come in as co-conspirator hearsay, vicarious admissions under KSA 6460.
But that isn't what you presented to the judge. You said 6460A, present and available for cross-examination.
Right,
Isn't that the reason that you gave to the judge for allowing the hearsay?
At the time the objection was made, we said he was going to be present to testify.
What were any other grounds or any other subparagraphs of 6460, any other exceptions argued to the judge?
I don't recall. I think at the time we expected Billy Craig was going to testify.
And if that's the sole basis, then it really doesn't matter whether the statements are incriminating or not, because he wasn't present and capable of being cross-examined.
Well, then we're looking at whether or not he was harmed or prejudiced. We go back down to exactly what the issue is here. The issue is, did the court commit error by denying the request for a mistrial? And that's what we're looking at, is the prejudice. Had we reached a point in the trial where the defendant couldn't get a fair trial, and where there was no way to fix it?
And what is our standard of review for that question?
It's abuse of discretion. There's actually, when you look at the Gleason case and the Harris case, there's kind of a 2-part test. And it always confuses me because the first part actually has 2 parts. So it's kind of a 3-part test. It's, was there a fundamental failure of the proceeding? Is it possible to continue without injustice? And then the second prong is, can the prejudice or prejudicial conduct be cured by jury admonition or other action? And then we look at whether the court abused its discretion. Now I want to hit on something that was a question about whether or not there'd been a plea bargain or some type of plea.
Well, yeah, I want to get into that because you represented to the court that Mr. Craig was going to be available for cross-examination each and every time this hearsay objection was made. And what assurance, what knowledge did you have that he was going to testify?
Well,
I mean, just saying he's available doesn't mean he's going to testify. You had information from his counsel that no, he's not going to testify. That was apparently given to you at some point during the trial.
No,
So
we
what
didn't.
basis did you have that he was going to testify?
The judge found in this case, and if you look at volume 8 of the transcript, page 71, that the state had a good faith basis for believing he was going to testify after she sat through the case and listened to all the facts. First of all, the defendant in his own criminal case, which is attached and is part of the appellate record in this case, filed the motion to enforce the plea agreement in his case. And he filed that before trial, before Mr. Logsden's trial. What he was trying to say is that at the time he talked to police and he made statements, he was being promised he wouldn't be prosecuted in return for the statements if he cooperated in the prosecution and testified. So he had entered in that agreement. He was trying to enforce that agreement in his case across the hall. That's part of it. So we had reason to believe if he wants to enforce his plea agreement, he's going to agree to testify when we call him to the stand. Second of all, we...
Explain that to me. You had refused the plea agreement. He's trying to get it, and so that means he's going to testify without the plea agreement?
Well, I'm not sure that I can explain it. He was trying to say that we had made
Let me see if I got this right.
Right.
You had withdrawn a plea agreement. Or you were not going to go through with
He backed out of the plea agreement.
Okay. But he had no plea agreement.
We didn't believe we had an agreement. He believed he had an agreement, and he wanted it enforced, and he had filed a motion in his case across the hall.
And so why would he gratuitously testify unless he got the plea agreement he was trying to enforce?
Well, he believed that he would get that plea agreement. It would be enforced as a contractual right across the hall by another judge.
We're talking past each other, I think, so.
So that was the state's impression, was that if he filed this motion to enforce a plea agreement, he intended to carry through with the plea agreement and cooperate with the prosecution. So that was one of the things that we had to look at. Another one was the fact that he had, we knew we could grant him testimonial use immunity. We were prepared to do that. In fact, I think the discussion was made at trial we could do that. We had contempt of court. That had worked with 4 witnesses during the case. 2 witnesses that said they wouldn't testify and changed their mind when threatened with contempt. 2 other witnesses were found in contempt of court and later purged themselves and did agree to testify. We had plea negotiations that were in fact throughout this case. If you look at volumes 8, pages 26 to 27, and volume, I think 17, pages 162 to 164, you'll see the plea negotiations were in effect. And there was a question asked about whether or not counsel for Billy Craig was aware he was going to be called as a witness. If you'll look, I can find it, it's in my brief. His attorney filed an entry of appearance on behalf of Billy Craig as a witness in this case long before trial. He entered his appearance as counsel for Billy Craig as a witness. That's in the appellate record. He knew that Billy Craig was going to be called as a witness. He filed a motion to enforce a plea agreement he believed he had with detectives that the state had signed off on early in the investigation.
There again, you're confusing me. Why would Craig's attorney need to enter an appearance in this case just because his client's been subpoenaed unless he wanted to be there, have the judge on notice that he was going to be there to protect Craig's rights?
Well, I think that's why he filed the...
Sure, and he's going to protect Craig's Fifth Amendment rights not to incriminate himself. And why isn't that a big red flag that he's not available to testify?
Because it was equally an indication that he was going to accept the plea agreement, or he's going to try to argue that this agreement should be enforced, and proof of it is the fact he was cooperating by testifying. And we were going to give him immunity. At least not immunity, it would be testimonial use immunity.
Did you ever, prior to asserting that he would be available to testify, check with Mr. Craig or check with his counsel that he indeed was prepared to testify?
I know that we talked to him. There was a conversation in the hallway, according to the record, in which he was told that his client was going to be subpoenaed as a witness in the case. And I know he had filed the motion, again, to enforce a plea agreement across the hall. I can't tell you specifically that his client ever said, my client's going to testify or not. But then again, when you look at the 100 witnesses that were called to trial, we had no guarantees any of them were going to testify when we called them to the stand. We had several of them we would ask if we had some reason to believe they wouldn't testify, we would have a hearing outside the presence of the jury. We did that in this case.
Was it a matter of just trial strategy to call him last as opposed to first so you could cure all this?
You know, hindsight, I guess you can look at it and say, maybe we should have called him first, but then we were also involved with plea negotiations, trying to get him, a happy witness would be better than somebody who was on the stand reluctantly. You know, we
I
had.
was going to ask a similar question, because I think our case law has been lax in not requiring as a element of the foundation for this hearsay exception that that be done. And many other, if not most other jurisdictions require that that witness be called to the stand first before you can utilize.
Well, now you're going to an area that I didn't brief, but I am aware that there is some case law out there that kind of indicates that it's preferred that a witness be called to the stand before statements attributable to that witness are presented. But there's a realization that if a case is so complex and so difficult to understand, sometimes going ahead and calling those witnesses in advance to explain it is okay. There's case law that I've seen on that. I think I put it in briefs maybe 25 years ago. The law is, we're calling him, we had a good faith basis. That was found by the judge.
But when you called him, you knew that he had not pled in this case, and you knew that his testimony would, by necessity, incriminate Billy Craig. Did you not?
No, because we were going to give him immunity. We were going to give him
that was
testimonial
after
use.
the fact.
That was when we called them. When we called them, we had the grant of testimonial use immunity.
But not when you represented to the court that he was available for cross-examination.
We represented that we were calling him as a witness, that he would be called as a witness.
Counsel, I think at one point, maybe 10 minutes ago, you basically said, so what? And that is, assuming all this to be error, where does that leave us on this case?
Well, we think the admonition in and of itself to the jury, especially when you look at the facts of the Sappington case, on this one witness, cured the defect. And again, as I started off, there was more than just the testimony of Billy Craig. There was 100 witnesses, there were 200 exhibits.
Mr. Schroeder, could I have you be a little more specific about that? I want to just assume with me for a moment. Okay. Assume we have a bunch of error. Assume that the admonition was incomplete. And just assume for the moment that we're not going to call that invited error by the defense. Can you be a little more specific than to say we had 100 witnesses and 200 exhibits? Why is this harmless?
I can't.
Okay. You were leading up to that.
We had 9 witnesses who said Logsdon made incriminating statements to them. We had incriminating text messages. We had a Colt .38 caliber revolver that was found in a residence where he was arrested in Nebraska, tested by the Kansas Bureau of Investigation, and it could not be ruled out as the murder weapon. It couldn't be identified as the murder weapon, but it couldn't be ruled out. We had recorded jail phone conversations in which he made statements. We had inconsistent statements he made to detectives. I mean, at one point, he said, I can't tell you everything because I would incriminate myself if I did. He made those kind of statements. We had, again, the recreation of the murder in the Ford County Jail. And I document in the brief and the facts, the fact law enforcement tried very hard to keep the facts very quiet so that nobody would know about them. There was some question about whether or not the defendant could have had access to those facts. And my recollection of the facts at trial and in my brief are that he didn't have recollection to those. And he recreated the homicide to the point of kneeling down on the ground and putting the gun up to his head when that was consistent with the facts that we knew about the crime. Jennifer Heckel was shot 3 times. There were 4 shots. One was a wing shot that went across her side. One was a through-and-through shot from her back to her chest. And the third was a shot directly to the back of her head. And he was recreating this. And we have other inmates in the cell there in Ford County saying, this is what he's telling us. He's telling us he did this. And then as we're asking him where he was when he told you, he said, out in the day room. And so they pulled the day room video on those days, and they see him doing it, just as they had described. We had other evidence other than the statements of Billy Craig. With regard to, I want to hit on this just as quick as I can. I know I'm running out of time.
You're out of time. I'll give you 60 seconds.
Give me 60 seconds. We talk about the witnesses that were left off of the admonition, and I can't remember which ones they were. I think it was Robert Hill. Robert Hill was talking, in fact, to the defendant. Well, again, I'm just going to say it was co-conspirator hearsay on Robert Hill. It was co-conspirator hearsay on Kayla Rodriguez. And on Kylie Hartman, we showed that was the defense who entered the statements that are being objected to. It wasn't the state that introduced those. So we're not sure really that other than those witnesses, there was anybody else that should have been included on the admonition.
How does the co-conspirator exception apply to counsel's point that the conspiracy had ended before these statements were made?
Well, because the statements were being made at the time of the murder hadn't been committed at the time those statements were made.
Not some of them. I mean, for example, Carruthers, that was made
No,
afterwards.
and I'm not claiming that's co-conspirator. Carruthers was a mistake.
Okay.
We acknowledge that Carruthers was the one mistake in this case that came out, and that's because the detective said he told them that the defendant that Billy Craig said the defendant had shot Jennifer Heckle. On the stand, that isn't what Carruthers testified. On the stand, Carruthers testified that Craig told him he didn't know anything about the murder. So it was an inconsistent statement. In person, Carruthers tells the jury, Craig didn't tell me that. It's the detective who says that. And we acknowledge that is the one error in over 100 witnesses in over 3 weeks of trial. That's a pretty good trial. I mean, this one error, but we think the admonition cured that. And that's the state's position on that.
Any further questions? Thank you, counsel. We reserve 3 minutes for rebuttal.
Thank you. May it please the court, I did find that letter from Mr. Stanton. It was actually to another defense counsel for Billy Craig, and it was dated September 16th, 2011, several months before the trial. And the last page says, "The unfortunate fact of the matter is your client has now indicated to law enforcement that he will no longer cooperate, and he is not willing to testify in this case. Additionally, your client has indicated to law enforcement that the information he previously gave, which we believe to be true and accurate, was not accurate, and he has indicated he did not tell officers the truth when providing that information. Because of your client's refusal to follow through with our agreed-upon disposition, your client now stands in a position where he may be charged with a crime of homicide involving Jennifer Heckle, and any agreement in reference to 11 CR 447 is null and void." This was sent by the prosecution to Billy Craig's attorneys prior to the trial.
What was the record cite on that?
I don't have that with me. I believe I did include it in the record, but I don't have that with me.
What, counsel for the state was pressed pretty hard about Mr. Craig and his knowledge about when he would testify. What about you pressing that at trial when these objections were made and saying, well, we don't have any information he's going to testify? That's absent from any kind of, at least any kind of reading I've done of the record, that you didn't press it, you just, you accepted that proposition was accepted.
Well, I don't believe he had any of this knowledge prior to the trial and prior to that hearsay statements being admitted under the exception that he was going to testify. At the sentencing hearing...
Just let me clarify. You're saying defense was unaware that the prosecution knew that Billy Craig, prior to this trial, was saying that he had given incorrect information about the trial previously?
That he was going to testify. I don't believe defense counsel knew about this letter regarding Billy Craig.
But didn't you say in the letter that Mr. Stanton said that Billy Craig was alleging his prior statements were inaccurate and not true?
And I believe that was the substance of the cross-examination of Mr. Craig. If he'd have been on the stand, we certainly could have gotten to that.
But you didn't make any allegation or you didn't raise any issue, a Brady issue about failure to turn over exculpatory evidence.
I
That's not
don't-
an issue here. is it?
Yeah, I don't believe that's an issue, because I don't believe that they necessarily withheld information. I guess maybe this letter was information they should have given him, but defense counsel for Mr. Logston. But I believe the state did know, and they did not talk to Mr. Logston's attorneys before the trial to tell them that, or I'm sorry, Mr. Craig's attorneys, to tell them that they intended to call him. The testimony at the sentencing on the motion for mistrial, Mr. Craig's attorneys testified that they did not have any communication from the state until October 23rd that they intended to call Mr. Craig. In addition, they also ran into the state on the steps of the courthouse, and Mr. Bell testified that he told Mr. Stanton that Mr. Craig was not going to testify. So the state knew that, at least partway through this trial, and they continued to assert that he was going to testify.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up? Do you believe you've made your points?
Well, I do believe I've made the points. I would submit to the court that there was reversible error here, and we'd ask the court to remand it for a new trial.
Very well, thank you. Thank you both for your arguments this evening. The court will take this matter under advisement. That concludes this evening's special docket. Court is now adjourned. And if you would please keep your seats while the court go to the right so we can safely meet you out in the commons area for reception.
All rise. You may be seated. Thank you.
Best ever. How long are they supposed to give? Okay, so is it? So is it safe to dismiss? Okay, I think if you want to dismiss everyone, go ahead.
How'd you hold up, sis?
Court is adjourned. You're excused.